So the California Supreme Court recently held that Prop 22 is unconstitutional. And that puts into question everything that Uber and Doordash have done to try to exclude their workers as employees. The statute was really interesting because first in chronological order came AB 5. And AB 5, as of January 2020, gave a different standard for how workers are going to be classified as contractors or employees. And all of the drivers for Uber and Doordash and all the rideshare companies potentially could have been reclassified as employees. And that business model that Uber has and Doordash have and Lyft doesn't really jive with having workers as employees, because what are you going to do? You're going to have somebody sit for 8 hours a day waiting for a passenger to say, hey, like, click on the app, I need a ride to the airport. It's not profitable. There's no way to and the people who are driving don't really want to be treated as employees. They want to be able to work 3 or 4 hours when they want to. They don't want the company saying, hey, you got to be available for 8 hours. Hang out on this corner or go to the airport and hang out for 8 hours until somebody comes through. That just doesn't make any sense. So the California Supreme Court held that to be unconstitutional, and now we're going to have to see exactly where this goes. The federal government is, there's a bill that's been circulated, and I believe it passed the House, potentially on its way to the Senate. It's called the PRO Act. And the PRO Act is going to take what California did with AB 5 and make it a federal law, which now means there's 3 elements about whether a company can classify a worker as a contractor. Those will become federal law, and it makes it much harder for anybody to be a freelancer, right? So imagine the bookkeeper you hire that works out of their house, the marketing person, anybody, your CPA who doesn't, maybe they're a small company, they don't have employees, they don't have an office, they don't have a lot of clients, they don't do any advertising. How are you going to confirm and show the government that this person really is an independent contractor? It's going to be pretty hard. So it's going to make it challenging and more costly for businesses and really prevent people from finding work that's suitable for them. Maybe they don't, these might be retired people who don't want to work long hours and they just want to have 1 or 2 clients, and that's all they really want. And there's a lot. The majority of businesses out there in the United States and in California are small companies. That's really the majority of what we're dealing with as small business owners. This Prop 22 basically says that the legislators' hands are tied for eternity. They could never change anything. And that's an interesting thing. So they might not, they say it's unconstitutional, but they might have directions to bring it down to the lower court that says, here's the instructions that what you can do. You can have your Prop 22, but limited it. There's probably going to be some limitations on it. So AB 5 was how we classify the workers. Prop 22 says we're never going to even get to AB 5. When it comes to being a driver for a rideshare company or Doordash, as long as you meet a couple elements and that definition, you're delivering people or product, then it eliminates that analysis and basically says you're automatically going to be a contractor. So it literally sidestepped AB 5 and basically said you're automatically a contractor. We're not even going to worry about AB 5. So what that means is if the the U.S. Supreme Court finds that the Prop 22 was truly unconstitutional, then all of these workers will have to go through that AB 5 analysis. And the chances are they may not be true contractors under that new analysis. So Uber and Lyft and Doordash threatened to leave California, and that's, I think, what we're looking potentially in a lot of different states who are going to follow the same. And AB 5 is not just California. It's the ABC test. There's many states that have that. In fact, about half of all states use the ABC test. Maybe not in the same, with all 3 elements. Some might have A and C, or A and B, or C and A, or different variations of that. Some might have all 3 elements, but they do have some form of that. So it's going to affect a lot of people in a lot of different states. Well, the Department of Labor basically, it's funny that that notes they had on, or that clarification they put out, in a sense it was just regurgitated what they've always been saying, and making it harder to treat a worker as a contractor. But when the PRO Act comes out, if it does pass the Senate and it becomes law in all 50 states, then they're going to just come out with a whole nother decision and interpretation that says, well, forget about what we said before. Yeah, all of these rideshare drivers, any drivers are really going to be employees. So it's actually going to make it even harder. They're going to change it again. I mean, you're going to have to do a lot more. You're going to have to be more established. You can't, just simply having a couple clients and no website, and if you don't have an EIN number and you don't have a business entity, it's going to be much harder. In the state of California, you actually have to have a business license really to pass AB5 at minimum for a lot of those exemptions. So yeah, you're going to have to spend a lot more money, which means you're going to have to hire potentially a CPA who's going to have to prepare another business tax return. It's going to cost more money for the business owner, which is going to increase prices. And in a sense, people are going to have to be forced to become employees when they really don't want to.